Oh gosh.
You are in the meeting now. Recording in progress.
Yes.
Yes. This is an audio test for the Zoom.
Oh, let me change my.
You want to try listening to the Zoom, Yuri, and tell me if you hear me? This is an audio test to the Zoom. Just making sure I am on the Zoom call. Oh, we're good. Okay, so you just want to leave out. This is a test for the Zoom call.
Yes, yeah. That's not bad.
I'm not in. Wait. Yeah, I'm trying.
Hello, Linda. This is Justin from the CTC. We're trying to send you a notice to move you over to panelists, so please accept that when you see it. Great, thank you.
I'm a sign language interpreter.
Hi,
I'm
Linda.
not
Yes.
a panelist. I'm a sign language interpreter. I wanted to know if a member of the panel is deaf or in the audience.
Hi, Linda. Thanks for being here. To our knowledge, we don't have anybody that is requiring the assistive services, but we do always like to have you on hand just in case.
Yeah, no problem. I will interpret anyway.
Yeah, because this is a
That's-
public meeting, so we do. Yeah, absolutely. No problem. Thank you for being here.
The interpreting agency also is trying to find a team for me. But if that's
Yeah,
not possible, I'll be okay. No
right.
problem.
So, yeah, I spoke with Jolene. She let me know that the other interpreter had canceled. We always like to have two on hand so you guys can take breaks. But this, I was telling her, this is going to be relatively less strenuous than some of our regular meetings. It was scheduled for 2 hours, but it's not expected to go that far. Maybe an hour to an hour and a half tops is the expectation. We don't have any like assigned or designated breaks during the period, but if that's something that you require, you just let us know, and we'll try to work with you however whatever works best.
No, should be okay. I see the agenda here and it's pretty short. But you never know. Things pop up.
Oh, absolutely. Right. Absolutely. Okay, great.
I can't figure out how to. Oh, here, let's do this. There we are. That's better. Okay. I interpreted the one in LA district and it was really interesting.
Oh, okay. Yeah. Yeah. They can be very interesting at times. Happy to have you back.
Yeah. I'm glad to be back. I love interpreting.
That's great. I'm glad you're doing what you love then.
Oh, just ask her to self-mute herself when she doesn't need to speak.
Okay. Yeah. We just wanted to issue a reminder to when you're not speaking to keep yourself on mute so we can avoid any background or any feedback noise.
I'm sorry, say that again. Say it again.
Just letting you know to remind you to keep yourself muted during the meeting when you're not needing to speak, so we don't have any feedback.
Right. Okay. If we do have someone that is deaf come to the meeting, how will I be notified that the deaf person wants to, let's say, voice or wants to add a comment?
We would
Let
probably,
somebody-
I would probably announce that over the microphone if that was the case.
Oh, okay. Okay.
Yeah, unless you prefer, I can also send you a private message as well. But yeah, we would probably, I would probably announce it if that was the need.
Okay. It depends on what the deaf person wants.
Right. Also, I wanted to let you know that today's meeting starts at 10, in case you were wondering. I appreciate you being here early. That's always very helpful, so we can always work out any kinks.
Mhm. I'm thrilled I got this going. Last time my team had to take over first because I couldn't figure out how to do things. This is a new laptop for me, and I'm still working out things.
Okay, well,
We know how that goes.
yeah, we can understand how that goes sometimes. So appreciate you.
Yeah. I'm going to go ahead and mute myself.
Okay, sounds good.
I just wanted to let you know that as an interpreter, I will not be able to join in any of the comments or anything like that. If I do any voicing for the deaf person, it will be that person's words, not my ideas or whatever. So I'm not going to be able to join as a part of the panel. But I just thought I'd let you know.
Okay, yes, we understand that. Oh, thank you.
Okay.
Hello, Commissioner Gardino. Welcome.
Thank you. I'm in a noisy place, so I'm going to turn off my mic.
Okay, thank you.
Okay, sounds.
Hello, this is Hillary.
Red, if it's red, then it's on.
Yeah, let me push.
Good morning, Commissioner Norton. Thanks for being on with us. We're going to get started here in just a couple minutes.
Excellent, thanks.
Good morning.
Good morning.
This is William.
Is it this one?
Hi. I'm
Oh.
glad that you guys are here.
I don't know. You're the only one that has that. I'm assuming this is for the chair.
I know this isn't on our agenda, Douglas, but we need to vote on whether we're accepting the news that Leanne posted on Facebook this morning. Is Leanne there?
Hi, Vice Chair. This is Tanisha. So we don't have Chair Eager here yet, and I'm not sure I know what the news she posted on Facebook is.
She's retiring from her day job. And
Oh.
I'm not sure we should allow that.
I'm not sure either. She's done a lot of good work. She should be here shortly, and we should be starting shortly.
Well, I plan to give her the business this morning. You let me know when she comes in.
I absolutely will.
Hi, guys. I'm going to be driving, so I'm going to just leave my screen off and the volume on. Looking forward to our briefing.
Can you hear me?
Yes, we can hear you.
Okay, great. We're going to start in like 1 minute.
Madam Chair, we've added to the agenda a full explanation of your Facebook post this morning. And then we're going to vote on it. Then we're going to vote on it.
Vice Chair, unfortunately, we didn't notice that action item, so we cannot take a vote.
Douglas, work with me. Work with me. Come on now.
I believe our Bagley-Keene attorney who's here would have an opposition to
I have
that.
a problem with that. Yeah.
Yeah. But Chair, aren't you leaving the Fresno EDC with a $27 million towel to cry into?
I am. You are right about that. When I started there 14 years ago, we had an $800,000 budget per year, and now we have an $8 million budget. I think they're fine.
There you go.
Well done. They're letting you take that with you, right?
Yeah. Write me a check for that.
Yeah.
No, I turned in my resignation letter to my board. You know, I have 40 board members, and it was unanimous. They all voted no, not to accept it. Said, can they do that? I don't know if we can do that.
Oh, goodness gracious.
You're doing great entertaining, by the way.
Morning, Madam Chair.
Good morning. Good morning.
I was wondering too. I'm like on my dongle. I think they said.
Okay, Douglas, we can start.
Thank you, Madam Chair. We'll start by calling roll, and we'll call roll for both the commission and the Equity Advisory Committee. Commissioner Bradshaw. Commissioner Cruz. Commissioner Falcone.
Present.
Commissioner Grisby.
Present.
Vice Chair Gordino.
Present.
Commissioner Lugo. Commissioner Liu. Commissioner Martinez. Commissioner Norton.
Present.
Commissioner Tavaloni. Chair Eager.
Present.
Senator Newman. Assemblymember Friedman. For the Equity Advisory Committee, Martha Armas Kelly. Alexandria Contreras. Michael Despain. Ana Gonzalez. Herb Hastings. Peggy Martinez. Amber Novi. Naila Pope Harden. Axel Santana. Connie Stewart. Randy Torres Van Vleck. Stella Ursura. Cheryl Villegas Walker. William Walker.
Present.
Christine Williams. Welcome all to the Bagley-Keene Open Meeting Act training. The agenda for this training is located on the Commission website at www.catc.ca.gov. Any document the CTC creates can be translated into any language you need. Simply email us at ctc@catc.ca.gov and we'll have them returned to you as quickly as possible. We encourage interaction with our stakeholders at these meetings, there will be opportunity for questions and comments at this meeting. You should see the webinar control panel likely located on the bottom of your screen. There you'll find the raised hand and Q&A tabs. We encourage you to use the raised hand feature as early as possible to give the system time to acknowledge you. Alternately, you may use the Q&A tab to submit your comment or question. Commission staff will then read the question on your behalf. As a reminder, each registered attendee is provided a unique link and phone number to access the webinar. These should not be shared with other participants, as this can create confusion for staff when making comments. Thank you.
Thank you, Douglas, and welcome to all of you for joining us for this session. As we all know, the California Transportation Commission and our advisory councils keenly use the Bagley-Keene open meeting, and we follow those rules to the T. And I think in the last year we looked at, let's make sure that we all know exactly what those are, what we can and cannot do and say, and how we meet. And so it was brought to our attention that we have a attorney here with us who is an expert in that field to walk us through that process. And so at this time, I want to introduce Malad Daljou. Is that right? Daljou? Yes. So I will turn that over to you. Thank you so much for joining us. We look forward to today.
Thank you, Madam Chair. Good morning, commissioners, committee members, and members of the public. Can you hear me? Great. So my name is Malad Daljou. I'm with the California Department of Justice, and I am here to give a very broad overview of the requirements of the Bagley-Keene Open Meeting Act. Complying with requirements of Bagley-Keene creates inefficiency and frustration because it deprives people of their natural communication patterns. As a member of a public body, especially for those from the private sector, it can be very counterintuitive complying with Bagley-Keene. But if you understand the purpose of Bagley-Keene, it may make it easier for you to comply with its requirements. Let's go to the next slide, please. The purpose of Bagley-Keene is not to promote government efficiency. If efficiency was the priority, the legislature would have created a department with a single executive director. Instead, the legislature created a multi-member body. In doing so, the legislature determined that consensus building was more important than efficiency. Consensus building process takes time and is very different from the individual decision maker model. The legislature also decided that the public should have a seat at the table. Bagley-Keene's open meeting, notice, public participation, and records requirements promote the public's ability to be part of this process. If you keep in mind that consensus building and public participation are higher priorities than efficiency, then Bagley-Keene requirements will be easier to understand and follow. There are 5 types of multi-member bodies that are required to comply with Bagley-Keene. The most common are multi-member state bodies created by statute or by an executive order. Because the Transportation Commission is a multi-member state body created by statute, it is required to comply with Bagley-Keene requirements. Next slide, please. Another type of body that is required to comply with Bagley-Keene is an advisory body of a state body. An advisory body is a subcommittee of a state body that consists of at least 3 members, has not been delegated any decision-making authority, and is created by formal action of the state body or a member of the state body. Members of an advisory body can be members of the state body, staff, or private citizens. Formal action includes any type of action of a state body resulting in an advisory body. For example, a state body directing its staff can qualify as a formal action. Formal action can also include implied ratification. For example, if 3 members of a commission regularly meet outside of a public meeting to discuss agency business, it is possible that the 3 members have created an advisory body. Therefore, we generally caution that no more than 2 members of a state body discuss agency business outside of a noticed public meeting. We refer to this as the rule of 2. Complying with the rule of 2 can help commissioners avoid inadvertent violations of Bagley-Keene. Next slide, please. Bagley-Keene also applies to multi-member state bodies that have been delegated any decision-making authority of a state body, such as an executive committee of a state body. Next slide, please. Finally, Bagley-Keene applies to private or local public bodies if a member of a state body serves on that local or public body in their official capacity and the body receives funding from that member state body. Next slide, please. It's also important to remember that individuals appointed to a state body are members as soon as they're appointed, even before they're sworn in. Next slide, please. Bagley-Keene requires all meetings of state bodies to be open to the public. A meeting is a gathering of a majority of a state body to deliberate on any matter under the jurisdiction of that state body. Deliberation includes not only decision-making, but also information gathering. Next slide, please. Bagley-Keene specifically prohibits serial meetings. A serial meeting is a series of communications, each involving less than a majority of a state body, but collectively involving a majority of the state body to deliberate any matter under the state body's jurisdiction. A serial meeting can occur through a chain of communications from one member to another, or when one person acts as a hub of a wheel and communicates individually to various spokes. A serial meeting can also occur directly or indirectly through intermediaries. A serial meeting can involve face-to-face communications, telephone calls, emails, texting, and nowadays any type of app on your phone or anything electronically, really. Again, the philosophy behind Bagley-Keene is to promote public participation in the deliberation process. Serial meetings are prohibited because when members of a state body engage in serial communications outside of a public meeting, the public is deprived of the opportunity to participate. Next slide, please. There are some narrow exceptions to the open meeting requirement. For example, staff may brief or respond to questions from one member at a time about an agendized item for a public meeting. But staff may not communicate the comments or views of one member to other members. That could constitute a prohibited serial meeting. Some of these concepts are pretty detailed, and I'm sure there will be some questions. I'll take the questions and try to answer them at the end of the presentation. Next slide, please. There are specific types of gatherings that are not considered meetings. For example, a conversation between a member of a state body and non-members, such as a member of the public or staff, so long as it is not part of a serial meeting, does not qualify as a meeting. There are limited exceptions for conferences, noticed non-governmental meetings, meetings of other governmental bodies, and social gatherings, so long as the majority of the members do not discuss any agency business. One-way confidential legal advice from staff counsel to board members is also not a meeting, so long as board members do not discuss the legal advice amongst themselves outside of a meeting. Next slide, please. Bagley-Keene requires meetings to be noticed at least 10 calendar days in advance, including posting notice on the internet. The notice must also be provided in writing to anyone who requests a copy of the notice. Anyone may request to receive notices for all meetings of a state body. Notice must include an agenda of all matters to be discussed at the meeting, including a brief description of each matter. The brief description should contain enough information about the matter so that an average person can make an informed decision whether to attend and participate in the meeting. If an agenda item concerns a contract, loan, or grant, we recommend that the description reflect the purpose, parties, and dollar amount of the contract, loan, or grant. Generally, items may not be added to the agenda after the 10-day notice period has passed. A board member may not discuss any item not on the agenda at the public meeting, even if no action is to be taken by the board. Next slide, please. Members of the public must have the opportunity to attend every meeting. You may not require members of the public to provide identification. In particular circumstances, security officers may require identification, but that information may not be shared with meeting personnel. A meeting like this one's a perfect example. If there was a requirement to show ID at the front of the building to building staff, that's allowed in certain circumstances. but members of your staff in the meeting here cannot require identification. Sign-up sheets must clearly state that they are voluntary, and identification may not be required to provide public comment at a meeting. Members of the public may record, film, or stream unless it is disruptive to the meeting itself. Opportunity for public comment must be provided before or during every meeting. The most common practice is to provide opportunity for public comment for each agenda item after staff presentation, but before deliberation by the members. Time limits may be imposed on public comment so long as they are reasonable under the circumstances. Next slide, please. When records are provided to a majority of the board, they must be promptly provided to members of the public upon request. Records prepared in connection with a meeting should be available for inspection at the meeting. Records provided by a third party, such as a member of the public, should be made available as soon as practicable. Next slide, please. The public has the right to monitor votes of each member, and Bagley-Keene requires that all votes and abstentions be public and recorded. The best practice is to use roll call for all decisions and to record votes in the meeting minutes for the meeting. Next slide, please. There are discrete and narrow exceptions to the requirement that all meetings of a state body be open to the public. This presentation will not provide a comprehensive discussion of every exception, but I'll touch on 2 exceptions that apply to all state bodies. Next slide, please. Under the personnel exception, a board may meet in closed session to consider the employment, evaluation, or dismissal of a public employee. The purpose of the personnel exception is to protect the privacy of the employee. In order to consider complaints or charges from an employee or other person regarding a disciplinary action or dismissal, the employee must be given written notice of their right to have the closed session moved into open session. The employee cannot demand to be admitted into closed session, but the body may invite the employee into closed session. If the employee asks for an open session and you have an open session, you still have the right to go into closed session to deliberate on the matter. Next slide, please. The board may also meet in closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session would prejudice the position of the body in litigation. To obtain legal advice from its counsel on a litigation matter, the board must follow specific procedural requirements. Not all advice may be heard in closed session, only legal advice related to the pending or imminent litigation. The closed session must be properly noticed. For litigation that has already been initiated, the agenda must include the title of the case. Legal counsel is required to submit a memorandum to the board stating the specific reasons and legal authority for the closed session no later than 1 week after the closed session takes place. However, the memo is confidential and exempt from disclosure. Information received and discussions held in closed session are confidential and may not be disclosed to outside parties by members of the board or staff who attend the closed session. It's important to remember that confidentiality is the privilege of the board or the commission and not the privilege of any individual members of the board. Next slide, please. There are special procedural requirements that apply to all closed sessions. The notice agenda must indicate that there will be a closed session, identify items to be discussed, and state statutory authority for the closed session. Before convening the closed session, the body must also announce in open session the issues that it will discuss in closed session and allow public comment on the closed session matter. The public may address in closed session only those matters listed on the agenda and announced at the meeting. Board members may not stray into other topics, even if those topics are reasonably related to the closed session that's been agendized. A staff member must attend each closed session to record topics discussed and decisions made in the closed session. After the closed session, the board must reconvene in public before adjourning the meeting. Only those staff members with essential roles may attend a closed session. Next slide, please. Failure to comply with Bagley-Keene can result in penalties and injunctive relief, including reversal of an action by the board, an action or a decision of the board. Next slide, please. That concludes my presentation. There are additional, more detailed resources available on the Office of the Attorney General's website. The webpage is included on the slide. And if anybody has any questions, I can try to answer those questions.
I'll start. So at each of our CTC meetings, we have commissioners that meet for dinner in between those meetings. Previously, they had been noticed and the public can show up. If it is, according to these rules, that it truly is just a social event and no business is being done at those dinners, do we need to notice those for the public?
So technically under Bagley-Keene, if members are not going to discuss any agency business, it does not need to be noticed or be an open meeting. I just want to say that our office advises that it is noticed, because I think realistically, it's hard to imagine that members of a commission get together and don't discuss anything. But technically, under Bagley-Keene, you're not required to notice it if you're not planning on discussing any agency business. That's
the other one was, I think there was some confusion previously about what we can discuss with more than 2 or 3 people and what we can't. If it's not something that we're going to vote on, if it's not agency actual business that's going to be coming up, can there still be those discussions? Let's just say, we're sitting up at the dais and someone texts to everybody else and says, what are we having for lunch? And there was a question about, oh man, we can't text each other about that because, that might look like, we're violating Bagley-Keene. So if you could discuss maybe that kind of thing.
absolutely. So I think it's probably good advice that optically it could be bad. So if members of the public see the commissioners texting each other, it could give the impression that there's serial communication going on, and there is a very specific express prohibition on serial communication to prevent exactly that type of communication. But again, if you're communicating about something that's not within the jurisdiction of the commission or the subject matter of the commission, then Bagley-Keene is not going to apply, and you can go ahead and do that. So obviously, what you're going to have for lunch, I think, is outside outside of your subject matter, so that's fine. We get a lot of questions, for example, about timing. If you're talking to your staff or a couple commissioners are expressing to staff, I think a Tuesday meeting is bad for me. Can we have a Wednesday meeting? Communications like that, generally we say, because you're not talking about something within your subject matter, those aren't going to fall within Bagley-Keene. But our advice, again, we tend to give really conservative advice. And so our advice is always, don't ever communicate with all the commissioners at once, because reply all is probably the most common way that Bagley-Keene violations occur. If staff or if the chair, for example, sends something out to the full commission, that's not a subject that has to comply with Bagley-Keene, and one of the commissioners says, oh, by the way, on this item, and accidentally replies all, that's probably the most common type of inadvertent violation of Bagley-Keene. So BCC is your best friend, I would say, especially for staff.
Madam Chair.
Yes, Vice Chair.
When you're done with your line of questions, if I may, since I'm not in the room, it's harder to signal. I have a couple of questions I'd like to pose at the appropriate time.
So I just had one more, and then it's you. So I sometimes in the meetings and the way that we're all set, I can't see if someone is saying, oh, by the way, I have a question. So I might get a text that doesn't say anything about the subject matter or anything, just says, oh, I have a question, and then I can call on them. What's your opinion about that?
I would say that you're okay with that as long as there's nothing substantive in there. I have a question because this is a bad idea. It's probably, not, but if it's If it's purely logistical, I think
Yes.
you're okay, and that's
Okay.
not going to be considered communication as far as Bagley-Keene goes.
Great, thank you. Okay, Vice Chair, you're up.
Thank you, Madam Chair. And thank you again for joining us today for this incredibly important briefing, training, retraining. And part of the reason that Chair Eager and I thought this would be so beneficial to us as well as our colleagues is that one, so many of our colleagues were appointed during the pandemic, and we have only been together physically for a few meetings because of the pandemic restrictions. And two, Bagley-Keene is just so important for us to do the public's work in a public way. So I'm going to ask a couple of questions just so that there's understanding by me and everyone in two subjects. One is serial meetings, because occasionally we will reach out to somebody on an item and we need to make sure that we are not going over the amount of conversations that we can have for a body of our size, and that the people with whom we're communicating aren't as well, so that we're counting how many people we speak of. So if one, you can go into depth on that. And then two, the penalties for violating Bagley-Keene, even when it's inadvertent, if you can review that, because as I recall, they are quite serious.
Absolutely, Vice Chair. I'll start with the penalties because the penalties are rather straightforward. So if a court finds that you have not substantially complied with Bagley-Keene requirements, there's a pretty small window. It's either 60 or 90 days that someone can file for injunctive relief and have a decision reversed. And so that's probably the most common remedy that happens. There are also criminal remedies available. Those are not as common, but those require some type of knowledge or some kind of you don't have to be aware, and I don't want to go into details of what criminal prosecution involves, but I can tell you inadvertent violations are very unlikely to lead to criminal sanctions. I think inadvertent violations are most likely going to lead, or really the only remedy is going to be to have the action reversed. And there is a pretty short statute of limitations on having the action reversed. Obviously, it's not beneficial for the state of California for someone to come 5 years later and say, hey, let's reverse this grant that where the money's already been sent. And for that reason, the legislature has made the time for someone to reverse an action by a state board pretty short compared to other remedies. But that's going to be the most common one. And there have been court cases where they've decided that substantial compliance is sufficient. Because the requirements are so technical, there have been cases where a court has said, you're 95% in compliance because you had this one comma that was in the wrong place on your agenda. We're not going to reverse the action of a court or of a state body. So, yeah, that's the penalties. I don't know if you have any specific questions about that, Vice Chair, if that covers, and then I'll move to the other question.
Thank you. That was helpful. And yes, please move on to serial meetings.
Absolutely. Did you have a specific question about serial meetings, or did you want me to just go more in depth about the restriction?
Yeah, it's so we are a voting body of 11, 9 gubernatorial appointees, 1 from the Senate and 1 from the Assembly Speaker. And then we have 2 ex officio members that bring us to 13. So first, what constitutes not engaging with a majority? Is it 5 out of the 11 or 6 out of the 13? And a reminder again, so that none of us make the mistake of avoiding serial meetings.
Absolutely. I'd have to take a look at your statutes because some state bodies, especially ones with this many members, there will be a statute that qualifies what a quorum is. Here you have 11 members, so I would say 5 or less technically don't qualify as a majority, and therefore you're not having a meeting.
Milad, we've actually outlined in our operating procedures, 6 is a quorum regardless of vacancies.
Okay, thank you very much. So if you keep it under 6, so 5 or less, in a closed world, in a complete vacuum, if those 5 members talk to each other, it's technically it's not prohibited by the serial meeting, and it's not a meeting. Now, in reality, we always recommend the rule of 2, because if you text another commissioner, and if you keep it within 5 commissioners, there's a pretty good chance that one other commissioner has said something to one of those commissioners, and then you're in trouble, right? And the 4 members that are talking to the 5th member may not know that that 5th member had a conversation in the hallway, or maybe had an email where they discussed the matter. And so technically, if you keep it to less than 6, so 5 or less, it doesn't constitute a meeting, and it doesn't violate the serial meeting prohibition. But we really highly recommend that you don't get anywhere close to 5 members, because these days, with all the electronic means of communicating, I think it's really hard for 5 members to keep track of who they've talked to and what particular matter they've talked to them about.
Let me bring it down to a practical level. What I do, and you know, I'll be transparent. You tell me publicly if I've been missing the mark. I will, if I'm calling someone, I will say, hey, on subject matter X, I'd like to speak with you. Have you spoken with anyone else on the commission? And then that person will respond yes or no, and I will know where I am in terms of Bagley-Keene and that up to no more than 5 rule. And then if I speak with that person X and we decide, well, we should speak with person Y as well, same thing. Person Y, X and I spoke about this. Have you spoken with anyone on this topic? And in that way, trying to make sure that in no way are we violating Bagley-Keene as we have a serial conversation. And I'd love your feedback.
Absolutely. I think that's a great practice, and it makes inadvertent violations much less likely. If you're only having telephone conversations with other members, and you're prefacing all those conversations with, have you talked to any other commissioners about this? Or again, serial communication is also worried about, have you talked to staff who have talked to other commissioners, right? So there can't be a conduit involved there between the commissioners. But that's right. If you are only having telephone or in-person conversations, and you start that conversation with, have you talked to anybody else about it? Then you're pretty safe as far as serial communication goes, if you keep it under 5. Our concern is, 5 members talk about, you preface all the conversations and you talk to 4 other members. And then a 5th member who doesn't know about this conversation sends an email to one of those 5 members and says, hey, by the way, I'm going to vote no on this matter. And then they've kind of muddied the waters and there's a Bagley-Keene violation. That's really the concern, especially nowadays with so much electronic communication. It's really hard to tell someone, no, I've already talked to 4 people about this, so please don't text me or email me about this subject. But the scenario that you do describe is probably as safe as you could be in having conversations with more than 2 people about a particular subject.
Thank you. I appreciate it. And since I mentioned all this publicly, trying to be transparent, I'm glad to hear I haven't been making a mistake.
Yeah. So one thing is, Bagley-Keene was written maybe 40, 50 years before 30 years before email and 50 years before social media. And so the way that it just wasn't designed for electronic communication, and it especially wasn't designed for social media and applications, whatever. And so it gets really murky and really difficult to follow Bagley-Keene with electronic devices, unfortunately.
Thank you, Vice Chair. I did have a question about the rule of 2. So I certainly understand that if 4 people meet regularly, that's a committee, and that has to be a formal process in order to decide whether a committee fits within the statute. So I get that part. If it's specific to a particular issue and they only meet once or twice, and I'll tell you exactly what I'm talking about. We are in the mode of searching for a new director. And there is a panel of folks that's going to be doing that initial look at resumes. They're going to meet twice to look at that before it comes to the full commission. So it's not necessarily a committee. They're not going to be ongoing. They're only going to meet twice, and they don't have regular communication. So does that still fall within the rule of two, or is that an exception?
How many members are there in this kind of ad hoc group?
We're calling it a panel.
Panel, sorry.
Yes, 4.
Okay, once you have 3 or more, if they're officially going to bring something to the full commission, like their recommendation, these are the candidates we're presenting, or this is what the search should look like, you're clearly within the realm of an advisory body that has to have Bagley-Keene meetings. The reason that we say rule of 2 is if you have less than 3 members, so if you have 2 members who regularly talk about a subject, and then it comes before the full commission, that doesn't qualify as an advisory committee, and they don't have to have public meetings. They can just have a discussion amongst themselves. Once you reach 3, if it's something that they're going to bring before the full commission, they do qualify as an advisory body. Statutorily, they do. That was that second group we talked about today. And the statute, Bagley-Keene specifically says 3 or more members with who have not been delegated authority, who are going to bring something before the full commission. And so it sounds like if the full commission is going to make the ultimate decision on the director, that seems to fall squarely within the advisory body definition. Unless I missed something, I'm sorry.
So then, but it's a personnel issue, and it would have to be in closed session because they couldn't have those discussions in front of public on people that are applying for a job. So does it have to be posted and then gone into closed session? Even though they're going to be online, they're not going to be in a public place.
You mean the director application is going to be posted online? I'm sorry,
No, the meeting. So do they have to post that they're going to have a meeting to discuss the applicants? Well, obviously that's not an open session.
Right.
Obviously that can't be for the public. So would they post that they're going to have that meeting and then go into closed session?
That's right. So they would have the same notice. They would have the same notice requirements as the full body, and the closed session requirement requires them to list for example, for this example, and I can be more specific if you guys send this to us and we can kind of review it. But generally, what we've advised to other boards is that you post the notice. You have to state the statute. So I think it's subdivision A, the personnel exception. Right. And we would also, I think we would advise that you say something to the effect of putting together application materials for a director for closed session. You state the exception. So they have at the meeting, they have their meeting, they come into open session, they take public comment. Now we're going on into closed session under government code, whatever it is.
Yeah.
And then you go into closed session after you take public comment. Then you just have to come back into open session. And you don't have to explain what you did. You can just said, we deliberated on a potential application, and then that's it. And then you can close the meeting.
Okay.
Yeah. It's exactly the same way that the closed session took place.
Yes.
At the other meeting.
Okay. We can do that. Thank you.
Yeah.
Any other commissioners, advisory council that have questions, staff?
I just want to make sure to understand that essentially our committee is held to the same rules. So we're not going to be talking outside of meetings as well. And so just for clarity. Yeah. Is that correct?
So your committee is comprised of 3 or more members?
Yes.
Maybe I could give Millad a little bit of a description of the committee. So the Equity Advisory Committee was formed by the commission, by an action of the commission. So it fits squarely under one of those bullets that you talked about as an advisory body. It is well more than 4. It's about 15, I believe, if I remember correctly.
Thank you. Then that's correct. Yes, they would fall under the same notice, agenda, and communication requirements as the full commission. It's technically called an advisory body. I call it a subcommittee. I think that's more intuitive. But the part that people that is not intuitive is that the subcommittee that has to adhere to Bagley-Keene doesn't necessarily have to be members of the commission. It can be members of the commission, it can be staff, it can be members of the public, as long as it's sanctioned by the full board or a board action and is bringing recommendations to the full board. It does qualify as an advisory body and thus has to comply with Bagley-Keene. So yes is the answer.
Short answer, yes.
Great. I'm here representing 15 people right now. So I just want to make sure that we're engaged, and I'll carry that message back to my committee. Thank you.
Yes, Commissioner Grisby.
Thank you for presenting this. It's a very interesting act. So let's say that there's a topic that we know may be on the agenda, say in 6 months or 8 months, but is not yet. Is it under the act possible to talk about the topic with more than the rule of 2?
So yes, up to 5 members can talk about it before it becomes a meeting. I think the question is, does it have to be something that's coming up soon or that's already been agendized? And the answer is no. As long as it's something, once it comes up, the fact that a majority of the members have talked about it or have gathered information together outside of a public meeting is going to be a violation of Bagley-Keene. So as long as you keep that within the rule of 2, I mean, if you're talking, as long as you keep that within the rule of 2, and that's why we recommend the rule of 2, is because you can talk about to one other member about anything you want, as long as you keep it within the 2 of you. But once you get to 3 or more, you start getting into the realm of Bagley-Keene violations. I don't know if that answers your question. Sorry, please let me know if it didn't answer your question.
It did, thank you.
Yeah.
And I just want to repeat though, to be careful even with the, quote unquote rule of 2, because if you're reaching out to one person before you say, hey, have you talked to anyone else on this topic? If you don't preface it, that person may have already spoken to what would then, if those 2 speak, put us over the cap of 5.
Yeah, so if I heard this correctly, so the rule of 2 is the meeting, right? You can't have more than 2 people that constitute sort of a committee or a meeting. We can't have conversations with more than 5. So there's a 2 rule and then there's a 5 rule. And I guess what's a little disconcerting with Commissioner Grisby's question is, we might have conversations about something that we don't know is coming before our commission, but then it does, right? A year later, all of a sudden, oh man, we've all talked about that bridge. We didn't know that was coming up. And there would have been 6 or 7 of us that had those conversations. So are you saying that still falls within this Bagley-Keene rule, even though that wasn't something we expected to come before us in the immediate future?
So that's really fact specific, and I would probably feel more comfortable if I looked at case law to see if that's something that a court has ruled on before. Our advice, again, our conservative advice is not to talk about anything within your subject matter. So if you're talking about a specific bridge or a train or something, I think the chances that that's maybe something that's going to come before you in the future is relatively high. But again, that's just our advice. What would happen in that case if you talked about something general, like I think San Francisco should have more X, Y, and Z, and 3 years later something comes up in San Francisco? That's pretty fact specific. And again, our advice is to just stay away from those topics, but because it is very fact specific. And if you want me to say yes or no with that, I want to do a little bit more research to see if there is an example of something that's come back and, a few years later. And what would be, I think it would be important for you to know how to remedy, right, set that out so that when you do come into a meeting, you've fixed that issue essentially.
Yeah, thank you. Because that would be what, if that came up a year later and we went, oh man, we had that discussion. Now what do we do about it before it comes before us, right? Because we'll know that's coming. So that would be good to know what would that remedy be. But I think Commissioner Grisby, you had a question.
Yeah, I had a follow-up. So essentially we can't talk about any policy issues of any notable import to the people of California, even if it's not noticed as a agenda item foreseeable future at all. So essentially, we can't have any policy conversations with our fellow members.
So that does seem harsh. And, I that's why when I start out this meeting, I say that it is very counterintuitive. And the priority with the legislation with Bagley-Keene is that the public has a seat at the table whenever this board or this body has discussions, even information gathering, they should have a seat at the table. And so I would say conceptually, yes, that's the concept. The concept is that a majority of the commissioners shouldn't be discussing any policy related to the work that you do without members of the public having an opportunity to be present. I understand that's really difficult. Bagley-Keene is not easy. And again, it really hampers efficiency. For a board, it really does. But that's the way they wrote it up. But if you have a really specific set of facts and you want us to take a look at it, and you're really concerned about something that you might be doing in the future, I would suggest that you reach out to staff, and staff can reach out to us and give you further guidance on that particular set of facts. But generally, yes, the answer is Bagley-Keene prohibits you from having policy discussions with with the majority of the board, even if it's something that's not going to be on the agenda in the foreseeable future.
Okay, thank you. Director Taylor, did you have a question?
I was just going to add to what Milad said. I think what's really important is the reason why we got to Bagley-Keene, right? Because the things that we're talking about really talk about the inclusion of the public through the entire sausage making process, because we got to Bagley-Keene because for a long time government didn't include the public in the sausage making process, and a lot of deals were cut behind closed doors. And that's the importance of Bagley-Keene, is having the open transparency process even when we're not having something before, so that we're not in an echo chamber as well, right?
That's right.
I mean, it's not necessarily decision making. It's more of let's say I know that the chair is an expert in economic development, and I want to learn more about that. And it has some tangential relationship to the work that we do here. It sounds like even that would be problematic. Because it's not decision making; it's information sharing, essentially.
It would be if economic development is something within the purview of the body, and also if that discussion is going beyond 5 people, right? So I think the most practical solution to that is that you're only having those kind of broad policy discussions with one other member. And again, it's difficult. And as the vice chair said, you kind of have to preface those conversations with, hey, have you talked to anybody else? Unfortunately, it's very inefficient, but that would be the safest way to do it, is to only have the conversation amongst 2 people and to kind of preface it with, let's not talk to any of the other members about this particular issue. But if you're talking about something really, really broad, like economic development, it's hard to see how that's going to be related to a specific issue that's going to be before the entire commission, right? So I think some of it depends on how broad the discussion is. If you're talking about economic development in San Francisco, I think that's easy to relate to a particular issue or an action item that may come up. But if you're just talking about, I mean, I don't know what a really broad subject is. I don't know your subject matter. But I think there are probably subjects that are broad enough that they're not specifically related to any action that you're going to take.
Well, in this case, it would be a complete correlation with things like our guidelines and talking about economic development when it relates to project choice, for example. I might learn something from her that might inform my opinions, but I didn't ask her about how she's going to vote on a particular item. It's just knowledge sharing that might lead to future edification of my own point of view on something.
Yeah, that particular example, again, if it's really fact specific, I would probably want to look into it a little bit further and get you a more complete answer. But it seems like with the facts that you've presented, I would really try to keep that within 2 members of that conversation about something like that, and try to not go beyond 2 members. Again, the limit is 5. But because of all the different ways of communicating now, we recommend 2. That's kind of our conservative, safest course of action. But the rule of 2, it's not in law anywhere. That's just we just consider that kind of the safest course of action.
I was just going to make a comment. This conversation came up previously when we talked about noticing dinners and receptions and things like that. And that's why we fail safe to do it, to noticing them, because of things like this, like two people talking. We invite local officials to our dinner or to our reception. Inevitably, something comes up that maybe down the road comes up on our agenda. And that's why we've defaulted to noticing those things.
Yeah, and I think that's the advice that I would give if someone asked me with those dinners. That's not necessarily required, like we talked about before, but for two reasons. One, because I think it's easy to stray into topics that are related to your policy. And two, I think if a member of the public is sitting at a table next to you and sees 12 members of the commission sitting at a table having dinner, it's going to bring up a lot of questions about, is this a notice meeting or not? And so by just having a notice posted, it kind of prevents some optics issues potentially. Or even a lawsuit, right? Someone can't come back and say, you guys talked about this at a dinner.
Sure.
And you end up not having to prove that you didn't talk about it at the dinner.
Can you talk a little bit more about the limit on public comment? You were at our LA meeting when we had a particular gentleman that we finally had to ask to leave, but what are those specific rules about what those limitations are? And we also had a meeting recently where, because of time constraints, we limited public comment to 1 minute, and the public felt like that was too restrictive, but it was, because we thought maybe there was going to be 200 people talking and we only had a limited time. So where would we find those specific rules?
Yeah, so Bagley-Keene doesn't have specific rules. It kind of has the lawyerly answer, which is as long as they're reasonable, which is difficult. So I can tell you, based on the practices that I've seen, a minute seems a little bit short, but I can say that you're safe with a minute if you see that you have 200 people who want to provide public comment and it's 10 p.m., the night of your meeting. I think 1 minute per person is reasonable in that circumstance. I think if you have a relatively short list of agenda items and there's only 5 people who are going to speak, limiting it to a minute may be seen as unreasonable. The most common, I think this was what your commission did at the meeting I was at. The most common is 2 to 3 minutes if there's quite a few members of the public that want to comment. I would say, from my experience, if there aren't a lot of people in the line to comment and you have someone like the gentleman at the last meeting, it's good to have that 3-minute limit for all the items. So worst case scenario, you just have to listen to someone for 3 minutes talking about something completely unrelated to the body. What's important is that you don't cut them off because they're saying really ridiculous things about the board or the work of the board. As long as they're commenting on something that's related to the board, they got the full 3 minutes, right? Or I would recommend that you give them the 3 minutes and just let them kind of run out of steam. Cutting them off a lot of times will agitate the person and make it worse. And you're getting into kind of pretty dangerous First Amendment, Bagley-Keene type issues. And so just letting them talk for 3 minutes, I think, is probably the best way to go. But you could, if you have a lot of commenters, you could probably limit it down to a minute and be fine. You can't, kicking somebody out, I think you probably already practice this, but should be last resort. If they're up there talking and taking up a ton of time and not talking about anything related to your subject matter, then you can have them removed if they're being disruptive as a last resort. But if they're talking for 10 minutes about why the work you do is so bad, then you just got to let them keep talking, unfortunately. It can't be based on their viewpoint.
Yeah, and I'm going to build on that if I may. What the chair is referencing is someone who was belittling other people, swearing to, at, and in front of the public and the commission and the people online. So there were, I would love to hear your point of view on people who are being abusive and whether, I mean, that's like the Supreme Court definition of pornography, right? I know it when I see it. Well, we don't always want to see it, but we want to know what we can cut off. So that's one, because that in my estimation, that person was truly being abusive to the public as well as to the commission. And it was kind of scary for a lot of folks. The second one is on resolutions of necessity. For whatever reason, in my 17 years on the commission, there's been a point of view that, oh, well, they can speak as long as they want, and they often do. Are there ways that we can notice in advance how much time someone presenting on a resolution of necessity can speak? Or is that something that truly we just let them speak as long as they want?
So under Bagley-Keene, you can always limit the time. I think, I don't know the specifics of this type of vote that you have. There may be some Administrative Procedures Act rules that apply to it, or some due process rules that I'm not aware of. But as far as Bagley-Keene goes, if you're good, if you set out at the very beginning, each public comment is limited to 3 minutes, for example, or 5 minutes. We've never seen any type of action brought successfully against a board for limiting it to 3 to 5 minutes. But again, there are probably a few types of actions that go before your board where you want to consider, I don't know if it's CEQA or due process outside of Bagley-Keene. And I don't know this particular type of action, so I wouldn't want to say for sure that you can limit the time on that.
And maybe I can add to what Milan had said about the resolution of necessity. One of the things that we have been previously advised, because it is kind of the last resort before we begin the formal eminent domain process, is that the court has generally ruled in our favor when we have given an ample amount of time for the property owner to air their challenges with the process. And so we have generally given them more time as a recommendation from our legal counsel.
Tanisha, thank you. I guess I've always wondered what adequate is, because it's tended to be, you just speak for as long as you want, no matter how many times you just are repeating yourself or whatever, rather than, okay, resolutions of necessity, you have up to 10 minutes or 12 minutes or whatever it might be. So
it's something that we can talk with our legal counsel about again, for sure. But I think it's that delicate fine line depending on the issues that are before us, right?
Okay.
I want to follow up on a comment made by Commissioner Gardino. Under what grounds could we remove someone for racist, sexist, homophobic comments?
So again, with something that specific, I think it would probably be best if you got some written advice from us, so we can look at examples where maybe the court has decided on this issue. I can't tell you off the top of my head what a remedy has been, but I would say under the reasonable standard, if it's disruptive to the meeting and it's not within what's been agendized, I think as long as you start incrementally and say, please keep your comments from not including racist, sexist, disruptive, vulgar language, and that person keeps doing it. I think the nice thing about virtual is it's easier technically to say, okay, your 3 minutes is up, and cut them off, right? In person, it's a little more difficult, but the expressed language is once they become disruptive, and it's not just their viewpoint that's disruptive, but it's the actual, like what they're saying is, like you're saying, is racist or vulgar. There is some deference that Bagley-Keene gives to the chair to remove people for being disruptive. And I think you can make a good case if someone's up there and they're not talking about any substance of what's on the agenda, but they're just up there just attacking individual commission members, not for the work that they're doing, but just for any of those reasons, what they look like, where they're from, anything that's not, hey, the work you're doing is good or bad, but they're attacking them personally. I think incrementally the chair can remove them at some point when they're becoming disruptive and they've been given sufficient warnings. Again, the standard is reasonable, right? So it's hard for me to say 3 warnings and they're out. But I've seen the chair run the meetings, and I think she,
We this last time, obviously he was rambling the first time. That was fine. And, we nodded and let him do his 3 minutes and cut him off at 3 minutes, which was good. When he came up the next time, and it was very offensive. And I think it was, Commissioner Norton that asked him, to please not do that. And, he said, I have my First Amendment rights. I could say whatever I want. But then when he did go into racist remarks and really did get abusive, we felt like that's when I asked him to leave, that thank you for your comments, but we're going to ask you to leave now. Thank heavens he did. But we could have gotten to that place where he didn't, right? But we had folks in the room that were gathering around him to lead him out, which worked out really well. And, we did have that anticipation, though, that he was going to come back, right? Because he had filled out cards for every single item on the list. So I guess it's, having something in writing saying, I do have that authority to ask him to leave, and that we can ask those folks in the room to not let someone come back in once they have been asked to be removed, I think. Right?
So, yeah, so absolutely. So Bagley-Keene does allow you to remove somebody if they're being disruptive. And I can say with certainty, saying racist, sexist things, being vulgar is definitely something that you can have someone removed for. That particular gentleman, I don't remember exactly what it was saying, but I remember that for every item that he came up and talked about, he was not talking about the item at all. He was like talking about Disneyland and like just all these things that were totally unrelated to the commission's work. Is that right? Do I remember that correctly? And then also being vulgar and racist. And so I think in that particular case, you would have the right under Bagley-Keene to have that person removed. If they're clearly not talking about the work of the commission, they don't have a First Amendment right to be in that room and say whatever they want. They have a Bagley-Keene right to be there and talk to the commission about the work of the commission. But if what they're saying during those comments is not related and it's just them being hurtful and attacking people personally, you absolutely do under Bagley-Keene have the right to have them removed. And as far as logistically how to do it, we can provide some guidance as far as like, when can you ask, it's not a bailiff, but when can you ask the security person or hopefully not one of your staffers to remove somebody? Yeah. I think Cal HR would probably have a problem with that.
Yeah.
Yes, sir.
But could there be like on every agenda for the commission, just guidelines of decorum that help, state what isn't accepted and what the limits of time are, so that you can just refer back to the agenda whenever there is an instance of disruption?
Absolutely. I think that's great. And it makes it, if you do remove somebody, having that having that written in the notice and in the agenda will justify it even more of removing that person. Absolutely. And it's something that your staff and hopefully your legal counsel can vet to make sure that, these elements are appropriate under Bagley-Keene to have some removed.
Oh, that's a great idea. Thank you so much. Douglas.
Doug may say something, but I'll start here. We do have some decorum rules in that long list of things that nobody reads on the agenda. It's even on this agenda, but we can certainly beef it up to include some of the things that Malad is talking about.
Some commissions do include a sentence in there that says the chair has the discretion to remove. Oh, okay, great. You're already there. Yeah. It becomes really difficult when the person is kind of talking about your work, but then also being vulgar or racist. Then that's the really hard one. And that's the one where it's really fact specific and there may not be any case law on that particular issue. So I think the best advice I can give you is just use common sense with that, right? There isn't like a specific guideline of what you have to do. Just be incremental and really make it clear that it's not viewpoint based on their viewpoint.
So do we have any other comments or questions from commissioners or advisory members? Commissioner Norton, we can't see you if you raise your hand, but do you have any questions or comments?
No, I thought this was really, really informative, and I thank you for all of the questions that were raised because they covered all of the issues that I had as well.
Great, thank you. Do we have any public comment?
No, I don't see that we have any attendees looking to comment at this time. Thank you.
Okay, thank you. Then with that, if we have no other comments or questions, we do want to again say a special thank you. We appreciate you taking the time to come and remind us of the rules and answer those specific questions. And we'll send you something with those specific issues that we can get a written response on. We appreciate it.
Absolutely.
All right.
Glad to be
Thank
here.
you so much.
Thank you.
With that, we are adjourned.